The U.S. Supreme Court has agreed to take up the question of whether President Trump's order ending birthright citizenship is legal. The decision follows Trump's appeal of a lower court ruling that struck down his executive order as unconstitutional. At issue is nothing less than the future of the 14th Amendment, which guarantees citizenship to anyone born or naturalized in the U.S. It's another major Trump immigration policy to reach the court, and the outcome could redefine a core principle of American law. The case will be argued this spring. Separately, a federal judge in Florida has ordered the release of materials from the 2005 and 2007 grand jury investigations into the late convicted sex offender Jeffrey Epstein. A similar request was denied earlier this year, but U.S. District Judge Rodney Smith said he is now granting the Justice Department's renewed petition in light of a new law Congress passed last month requiring the department to disclose all of its records related to Epstein. It remains unclear when the documents will be made public, but the law sets a deadline of December 19th. The Virginia man charged with planting pipe bombs in Washington, D.C. on the eve of the January 6th Capitol attack reportedly confessed to the act in interviews with investigators.
Okay, so the clock is now officially ticking toward a deadline that could blow the classified document scandal wide open and expose the full devastating scope of Donald Trump's criminal conduct to the American public, whether he likes it or not. And the pressure on Trump-appointed Judge Aileen Cannon has just intensified dramatically in ways that threaten to completely unravel everything Trump thought he had accomplished when Cannon controversially dismissed the entire case against him last year. The 11th Circuit Court of Appeals has now issued what can only be described as a brutal directive to Judge Cannon, giving her a hard deadline of January 2nd, 2026 to finally rule on motions from transparency groups and media organizations seeking to unseal Special Counsel Jack Smith's comprehensive final report on the classified documents investigation, a report that contains damning evidence of Trump's willful retention of national defense information and his elaborate obstruction scheme to hide those documents from investigators. The appellate court's November 3rd order gave Cannon exactly 60 days to either lift her January 2025 injunction that has been blocking release of the report, adjust that injunction in some way that would allow at least partial release, or reaffirm the injunction with proper legal justification that can withstand appellate scrutiny. And if she fails to act or issues another legally dubious ruling protecting Trump, the matter goes right back to the same appeals court that has already reversed her once and shown willingness to curtail her authority when she exceeds proper judicial bounds. But before we go any further, real quick, let's be honest, you can't really trust headlines anymore. That's why we built Pump Politics to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
The Trump administration has unveiled its national security strategy. That's a congressionally mandated document that each administration uses as its worldview. This one focuses overwhelmingly on the Western Hemisphere. The 33-page document said the U.S. would reorient its global military presence with a focus closer to home, countering migration and combating drug trafficking. It also took aim at longtime European allies, saying they hold unrealistic expectations for the war in Ukraine, and making clear that the U.S. wants to mend its relationship with Russia. The document also calls for an end to NATO expansion, and it charges Europe with taking primary responsibility for its own defense.
This deadline creates an extraordinary situation where Trump's own handpicked judge, the judge he specifically wanted to handle his case because he believed she would be favorable to him, the judge whose dismissal of the prosecution was celebrated by Trump as a complete vindication, is now being forced by a higher court to actually address transparency motions she has been sitting on and ignoring for months, while hoping the controversy would simply fade from public attention. Cannon has been using every procedural tool available to delay any ruling on unsealing the Smith report, apparently hoping that if she just waited long enough, the political landscape would shift in ways that would make release less damaging, or that some other development would give her cover to keep the report permanently sealed without having to provide legal justification that could withstand appeal. But the 11th Circuit has now made clear that this delay strategy has run its course, and that Cannon must actually do her job as a judge by ruling on the pending motions one way or the other by the January 2nd deadline. Regardless of how politically inconvenient that ruling might be for the former president, she has repeatedly protected throughout these proceedings. The report that transparency groups are seeking to unseal is not some minor procedural document or routine legal filing. It's the comprehensive final report that Special Counsel Jack Smith prepared, documenting the full scope of his investigation into Trump's handling of classified documents After leaving the presidency, the evidence his team assembled proving criminal conduct, the legal analysis supporting felony charges, and the conclusions prosecutors reached about Trump's guilt. This report includes what's known as Volume 2, which contains detailed obstruction evidence showing exactly how Trump orchestrated an elaborate scheme to prevent the government from retrieving classified materials he had no right to possess, how he directed employees to hide documents from investigators, how he made false statements through his attorneys, and how he systematically obstructed justice at every turn. Trump has been fighting desperately through his lawyers to keep Volume 2 and the rest of the report permanently sealed and hidden from public view, arguing that release would be unfair to him and would prejudice potential future proceedings. Arguments that transparency advocates say are just excuses to hide damning evidence of presidential criminality from the voters who have a right to know what their leaders have done. The 11th Circuit's willingness to impose this deadline on Cannon is significant because it shows the appellate court is watching her closely and is prepared to intervene if she continues making legally questionable rulings that seem designed to benefit Trump rather than to apply the law fairly and impartially. This is the same appeals court that previously reversed Cannon's appointment of a special master to review documents seized from Mar-a-Lago, finding that her ruling in that matter was legally unjustified and showed favoritism toward Trump that exceeded proper judicial bounds. The appellate panel's November 3rd directive makes clear that Cannon cannot simply continue ignoring pending motions indefinitely or issuing delay after delay while the clock runs out on public interest in the case. She must rule, and she must rule by January 2nd, 2026, just weeks away, or face having the appeals court step in and potentially rule on the unsealing motions itself in ways that Cannon cannot control and that Trump cannot predict or influence. Trump's legal team has been making increasingly desperate arguments, trying to convince Cannon to keep the Smith report permanently sealed, arguing that release would violate Trump's due process rights, would be unfair because he never had a trial where he could contest the evidence, and would constitute prosecutorial overreach by allowing a report to substitute for a proper adjudication of guilt. These arguments have some surface appeal, but they ignore the fundamental principle that the American public has a right to know what their government has learned about potential presidential criminality, especially when the only reason there was no trial and conviction was Trump's return to the presidency and the Justice Department policy against prosecuting sitting presidents, not any determination that the evidence was insufficient or that Trump was actually innocent of the charges. The special counsel concluded explicitly that there was sufficient evidence to convict Trump on multiple felony counts, and that prosecution would have proceeded to conviction if not for the constitutional issues surrounding prosecuting a sitting president. The public has a legitimate interest in seeing that evidence in those conclusions, and transparency advocates argue that interest outweighs Trump's preference to keep his alleged crimes hidden from view. Alright, so let's really dig into the procedural history that brought us to this critical moment, what the 11th Circuit's directive actually requires Judge Cannon to do, and why the January 2nd deadline creates such significant legal and political risks for Trump that his team has been fighting so desperately to avoid. The classified documents case against Trump was dismissed by Judge Cannon in July 2024 on grounds that the appointment of special counsel Jack Smith was unconstitutional because he was not appointed through the normal confirmation process that applies to principal officers of the United States government. This ruling was highly controversial among legal scholars, with many experts arguing that Cannon's legal reasoning was deeply flawed and ignored decades of precedent supporting the appointment of special counsels in exactly the manner Smith was appointed. The Justice Department initially appealed the dismissal, but after Trump won the 2024 election and returned to the presidency, the department dropped the appeal because of the long-standing policy against prosecuting sitting presidents, not because the legal arguments against Cannon's ruling were weak, but because continuing the prosecution became legally and practically impossible once Trump took office again. The dismissal of the criminal case did not end all legal proceedings related to the investigation. However, because various motions remain pending regarding what happens to the evidentiary record, the special counsel's final report, and other materials that were assembled during the investigation, transparency groups, including news organizations, good government advocates, and public interest legal organizations filed motions seeking to unseal the Smith report so the American public could see what the investigation found, even if there would be no criminal trial. Trump's lawyers opposed these motions, arguing that the report should remain permanently sealed to protect Trump's reputation and his rights. And Judge Cannon, rather than ruling promptly on these contested motions as judges normally do, simply sat on them for months without taking any action, allowing the controversy to fade from daily headlines while the report remained hidden from public view. This delay strategy worked for a while because there was no mechanism to force Cannon to rule on a particular timeline. Judges generally have discretion about how quickly they address pending motions, and while excessive delay can be criticized, it's difficult to compel a judge to rule faster than she chooses to rule. But the 11th Circuit's November 3rd directive changed that calculus dramatically by imposing an explicit deadline that Cannon cannot ignore. the appellate court ordered Cannon to address the pending motions regarding unsealing within 60 days by January 2, 2026, without requiring any further response from the parties. This unusual procedural move suggests the appeals court was concerned about Cannon's extended delays and wanted to force action on motions that had been languishing without resolution for far too long. The directive puts Cannon in a position where she must either grant the unsealing motions, deny them with legally sufficient reasoning, or modify her earlier injunction in some way, but she cannot simply continue doing nothing while hoping the issue goes away. The specific injunction that the appeals court directed Cannon to address is the order she issued in January 2025, blocking release of the Smith report shortly after it was completed. At that time, with Trump about to take office for his second term, Cannon granted Trump's emergency motion to prevent the report from being released publicly or provided to Congress, reasoning that release would be inappropriate while related proceedings were still ongoing and that Trump had due process interest in preventing dissemination of unproven allegations. Critics argued at the time that this injunction was legally questionable and seemed designed to protect Trump politically rather than to apply neutral legal principles. But with the criminal case dismissed and Trump returning to the presidency, there was limited appetite for immediate appeals of what seemed like a collateral matter. Now, however, the 11th Circuit has made clear that the injunction cannot simply remain in place indefinitely without proper justification. Cannon must either lift the injunction and allow the report to be released, adjust the injunction in some way that addresses the transparency concerns while protecting any legitimate interests Trump might have, or reaffirm the injunction with legal reasoning that can withstand appellate review. Given the appeals court's previous willingness to reverse Cannon when she exceeded proper bounds in her rulings favoring Trump, there's significant risk for Trump that whatever Cannon does will be appealed and potentially reversed if it appears to be another legally dubious ruling designed to protect him from accountability rather than to apply the law fairly. The contents of the Smith report that Trump is so desperate to keep hidden are understood to be extraordinarily damaging based on what has already been revealed through court filings. The January 2025 summary report that was released and testimony from witnesses who have discussed the investigation. Volume 2 of the full report reportedly contains comprehensive obstruction evidence showing in granular detail exactly how Trump orchestrated his scheme to prevent the government from retrieving classified documents, the specific instructions he gave to employees about moving boxes, the false statements he made through attorneys, the consciousness of guilt demonstrated by his frantic efforts to conceal documents he knew he had no right to possess. This evidence goes far beyond what has been publicly disclosed and would allow the American public to see for themselves the full scope of presidential criminality that prosecutors documented through their investigation. The report also reportedly contains analysis of the classified documents themselves, what categories of national security information they contain, how sensitive that information was, what damage could result from improper disclosure, and why Trump's cavalier handling of these materials at his beach club resort, where foreign nationals and random visitors had access, represented such a serious national security threat. While the actual classified documents obviously cannot be released publicly, the report's description of what categories of information were involved and how seriously the intelligence community assessed the potential damage would help the public understand why this case was so significant and why prosecutors concluded felony charges were warranted. So let's break this down into what you need to understand about the January 2nd deadline and what it means for Trump's desperate efforts to keep the classified documents evidence permanently hidden from public view. First major point, the 11th Circuit's directive represents a significant judicial check on Judge Cannon's extended pattern of delay and procedural maneuvering that has kept the Smith report sealed for nearly a year since it was completed, and it shows that higher courts are watching Cannon closely and are prepared to intervene if she continues issuing rulings that appear designed to protect Trump rather than to apply neutral legal principles fairly. Cannon has been widely criticized by legal experts throughout the classified documents case for rulings that seem to favor Trump in ways that exceeded normal judicial discretion, and the appeals court has already reversed her once when she appointed a special master to review seized documents in a ruling that the 11th Circuit found legally unjustified. The November 3rd directive imposing the January 2nd deadline suggests the appeals court is concerned that Cannon's extended delay on the unsealing motions represents another instance of improper favoritism toward Trump, and the explicit deadline removes her ability to continue running out the clock indefinitely. This matters because it means Cannon must actually rule on the merits of the unsealing motions rather than simply ignoring them and hoping public interest fades over time. Whatever she decides will be subject to appeal, and if her ruling appears legally dubious or seems designed primarily to protect Trump from embarrassment rather than to apply proper legal standards, the 11th Circuit has shown it's willing to reverse her and impose a different outcome. Trump cannot count on Cannon to protect him indefinitely because her rulings are subject to review by judges who have already demonstrated skepticism of her approach to this case and willingness to curtail her authority when she exceeds proper bounds. Second major point, the potential unsealing of the full Smith report would be devastating for Trump's efforts to claim vindication and to characterize the dismissed prosecution as a witch hunt that found nothing, because it would allow the American public to see the comprehensive evidence of his criminal conduct that prosecutors assembled over years of investigation. Trump has been telling his supporters that the dismissal of the case proves he did nothing wrong and that the entire investigation was politically motivated persecution by his enemies. But the dismissal was based on a technical legal ruling about the special counsel's appointment, not on any determination that the evidence was insufficient or that Trump was innocent. The Smith report documents in detail exactly what evidence prosecutors found, why they concluded it was sufficient for felony convictions, and what crimes they believe Trump committed. Public release of that report will completely undermine Trump's vindication narrative and would force his supporters to confront the reality that their president was found by career federal prosecutors to have committed serious crimes that would have resulted in conviction and imprisonment if he were any other citizen. The January 2025 summary report that was released provided only a high-level overview of the investigation's conclusions without the detailed underlying evidence and analysis that the full report contains. That summary made clear that prosecutors believed they had proof beyond reasonable doubt that Trump committed multiple felonies, but it didn't provide the granular detail that would allow the public to evaluate that conclusion for themselves. The full report, including Volume 2 on obstruction, would provide that detail, the specific evidence, the witness statements, the documents, the recordings, the analysis showing how all the pieces fit together into a comprehensive picture of intentional criminal conduct. Release of that level of detail would be far more damaging to Trump than anything that has been disclosed so far, because it would make the evidence tangible and undeniable rather than abstract and subject to dispute. Third major point, the timing of the January 2nd deadline creates maximum political pressure on Trump at a moment when he's already facing cascading legal and political crises across multiple fronts simultaneously and cannot afford another major scandal dominating headlines. The deadline falls just after the new year begins, ensuring that any ruling Cannon makes, whether to unseal the report or to try to keep it sealed with reasoning that will be immediately appealed, will generate major news coverage at a time when political attention is high and when the 2026 midterm campaign season is beginning to take shape. If Cannon unseals the report, the contents will dominate coverage for days or weeks as journalists and analysts dig through the detailed evidence of Trump's crimes. If Cannon tries to keep the report sealed, that decision will itself generate coverage about what Trump is trying to hide and will likely be appealed immediately to the 11th Circuit, keeping the controversy alive and prominent in the news. This timing intersects with all the other crises we've been tracking throughout these videos. The impeachment vote that Al Green is forcing before Christmas will have just happened or will be about to happen. The contempt threats against Kash Patel and the fallout from Pam Bondi's courtroom meltdown will still be generating coverage. The asset seizure proceedings threatening Trump's properties will be continuing. The Smith report deadline adds another major front to an already overwhelming legal and political assault on Trump's position, and the cumulative effect of all these simultaneous crises makes each individual crisis more damaging because they reinforce each other and create a narrative of an administration and a president completely overwhelmed by accountability and scandal. Fourth major point, Trump's arguments for keeping the report permanently sealed are legally weak and are primarily designed to delay disclosure rather than to establish any legitimate basis for permanent secrecy about presidential conduct that the public has every right to know about. Trump argues that release would be unfair because he never had a trial where he could contest the evidence, but there was no trial specifically because he won an election and returned to the presidency, not because the evidence was insufficient or because he was found innocent. He argues that release would prejudice potential future proceedings, but any future proceedings would involve the same evidence that prosecutors already have, and public awareness of that evidence doesn't change its admissibility or its probative value. He argues that release would violate his due process rights, but there is no due process right to keep evidence of presidential misconduct permanently hidden from the public that has every legitimate interest in knowing what their leaders have done. The fundamental principle at stake is whether the American people have a right to know what a comprehensive federal investigation found about potential presidential criminality, or whether a president can use legal maneuvering to keep that information permanently hidden simply because disclosure would be embarrassing or politically damaging. Transparency advocates argue that the public interest in knowing the truth about presidential conduct far outweighs any privacy or fairness interests Trump might assert, especially when the only reason there was no trial and conviction was the constitutional protection afforded to sitting presidents, not any determination that Trump was actually innocent of the crimes he was charged with. So where does this leave us as we approach the January 2nd deadline? We have the 11th Circuit imposing a hard deadline on Judge Cannon to rule on motions to unseal the Smith report. We have Cannon forced to either lift her injunction, adjust it, or reaffirm it with proper legal justification, but she cannot continue ignoring the motions indefinitely. We have Trump's lawyers desperately arguing for permanent sealing, while transparency advocates push for public release of evidence documenting presidential crimes. We have the appeals court watching closely and prepared to intervene if Cannon issues another legally dubious ruling protecting Trump. We have the full Volume 2 obstruction evidence potentially about to become public, showing exactly how Trump orchestrated his scheme to hide classified documents and obstruct the investigation. And we have all of this happening while Trump simultaneously faces impeachment votes, contempt threats against his appointees, asset seizure proceedings, and the cascade of other legal and political crises we've been tracking. The January 2nd deadline is approaching fast, and whatever happens when it arrives will generate massive news coverage and significant political consequences for Trump at the worst possible time for him politically. If the report gets unsealed, the American public will finally see the full documented evidence of Trump's classified documents crimes. If Cannon tries to keep it sealed, that decision will be immediately appealed, and the fight will continue in a court that has already shown willingness to reverse her. Either way, Trump cannot escape accountability on this front indefinitely, and the clock is now ticking toward a deadline he cannot delay or avoid. Keep watching because the January 2nd deadline will arrive in just weeks, and whatever ruling emerges will be one of the most significant developments in this entire scandal since the case was first brought. The evidence of Trump's crimes is sitting in that report, waiting to be exposed to public view, and the only question now is whether Judge Cannon will continue trying to protect him or whether the appeals court will force transparency that Trump has been fighting desperately to prevent. Stay tuned because this deadline could change everything.